Once again for The Law in You. Back with us tonight, attorneys Greg Fellerman and Ed Ciarimboli. They're rested after the weekend, ready to answer your legal question tonight.
Listen, Greg is more rested this weekend than he has been recently because he's not saving people's lives. Did you know that, Dave?
You know what? I did see the newspaper article about
Saving
the Kirby Park incident.
Saving kids' lives.
Greg's a hero.
No, I rendered aid. The kid needed it. We act. That's what you got to do. I saw
Nice job. Yeah.
Thank you. But
Something
the
to be
kid.
proud of.
Thank you.
Absolutely.
Could have saved a life for sure.
Wow.
All right, here's our question tonight, and we're talking to Sid in Tannersville here. Sid says, my son was working and slipped on a wet floor walking into the lobby at his place of work. He broke his arm, and worker compensation won't pick up the claim. Are they rights?
No, obviously, if he's injured in the course and scope of his employment, then they have to pick up their claim. That's workers' compensation. It's a no-fault, no-fault system. So workers' comp does have to pick up the claim. I mean, there are some, we need a little bit more information, to make sure that he was in the course and scope of his employment at the time. But if he was, then then comp's going to have to pick it up. But does it say that he was walking into his place of employment or somewhere else?
Into his lobby.
It sounds the lobby where he works.
I like that fact.
Yeah, the other thing you want to find out is he may potentially have a third-party case if there's a maintenance company that's supposed to be maintaining the lobby area of that building. If it's an outside maintenance company, then he may have a comp case, and he may also have a third-party case.
Or it could be a separate landlord, not his employer.
Right.
So we don't know where he works at.
There's
a whole bunch of issues, but like from a comp perspective, I think you're good. You're in your place of employment at that time. You have to find out. Obviously, we always tell people when you're injured at work, you need a lawyer. It's very complicated. It's adversarial, and you may even have a third-party case. Someone else may be at fault, so your employer would want to get that money back that they're paying because it's really not their fault. Complicated case, call us.
Easy to do. The number is on your screen. The website, just as easy. And don't forget, results matter. Attorneys Greg Fellerman and Ed Ciarimboli. We'll see you next time.
Thanks, Dave.
PAHomepage.com and the Law and You hotline are there for you.